Judge Heflin, you've spent a lifetime in service to the citizens of Alabama as a lawyer, as the Chief Justice of the Alabama Supreme Court, and as a senator representing the state. We are delighted to have this opportunity to hear the history of judicial reform in Alabama, particularly from you, because you were the major leader of that effort, and we're interested in your views on other issues. Thanks for welcoming us to Tuscumbia. It's nice to be here, my first time. Shall we get right into judicial reform?
Well, first let me say that I'm sorry that I could not appear personally, but it is a real pleasure to be with the League of Women Voters.
You go back, don't you?
I have admired the work that they have done over the years and the stances that they have taken on really some very crucial issues affecting the state and the nation. So it's a pleasure to be with you today by video and to maybe hopefully will be of some benefit to you in the future. I look to the League of Women Voters to take the leadership role in many issues that will be affecting the state in the future.
They will be delighted to hear your message and be inspired, and hopefully we will work harder because of it, because indeed that's what we're about, public policy issues that affect good government in the state. Let's get into judicial reform, and first I think people need to know, why did we need judicial reform?
Well, it had been an issue that went back to about 1912, I believe. I may miss the year, when Governor O'Neill called for judicial reform. There were a great number of courts in the county, and there might be 3 or 4, and they were duplicating their work, and the rules of practice and procedure were out of date. Then again, in the Folsom administration, the legislature appropriated $50,000 to have a study of the court system of the state, and to
at that point it was still a hodgepodge of courts, wasn't it?
Hodgepodge of courts, and the federal rules of civil procedure had been adopted and were being in the federal government and were being followed by a number of states. And there were a large number of lawyers that felt that we ought to pursue that, which would bring up the procedures and the practice in the courts. And they had some really outstanding consultants that worked with them, and but it got filibustered.
Oh, in the state legislature, you're saying?
In the state legislature, in the Senate, and so it didn't pass. Then there came along a lot of things that happened. Alabama, unfortunately, developed a reputation as being a quickie divorce state, and that brought a lot of ill publicity about the court system. There was a lot of misuse of the court system at various places, such as the quickie divorces. And then the justice of the peace, the issue was up, beginning to be looked upon as being a very bad system, and that the courts really ruled that you couldn't, justice of the peace wasn't really due to be operated as they were, because
as a kind of court.
Well, it had, the only way the justice of the peace got his fees was that he had to fine for either the state or he didn't get a fee if he found somebody not guilty. He wouldn't get any fees. On a civil case, if he's collected money for a person or a business, he wouldn't get his fees unless he found for them, and regardless of what the facts were. And many of them misused it. And there were, of course, honest ones that worked with it. That came along, and there was a feeling that there had been some instances of judges, particularly with the quickie divorces, that were disciplined, but it was a very cumbersome type of discipline. And then the judges, while they had a supernumerary system for for retirement, which was a farce, but it was a way their widows had no benefits. Mm-hmm. And so then the fee system was in many counties was causing a lot of problems. The fee system was in clerks. Every case would file, they'd get a fee themselves, and rather than going to the coffers of the state treasury or the county treasury. And so a lot of things were happening like that. We had worked with the American Judicature Society. And the American Judicature Society had been very successful in several states by having some reform by the use of citizens' conference on courts. Mm-hmm. And they would select about 200 leaders over the state and from representatives from various organizations. And almost everywhere they went, they would select representatives from the League of Women Voters, who then would go back and tell their members what they had heard about it. And they brought in experts and speakers to tell you, and it was about a conference was about 3 or 4 days in length. Well, when I was president of the Alabama State Bar Association, we formed a committee to determine whether we ought to have a citizens conference on courts for Alabama. Mm-hmm. And Robert Cunningham of Mobile was the chairman of that committee, and they recommended that we have a citizens conference. And so the citizens conference met just following my tenure as president of the state bar, but my successor gave me a lot of leeway to do what I wanted to do pertaining to a citizens conference. And some outstanding judges, outstanding lawyers, and outstanding laymen began to select people that they thought would be effective in regards to helping with reform of the courts. And they brought these people together, and they had a citizen conference, and they came up with a recommendation on various things that they thought were needed for Alabama.
Like rules and procedures.
Yeah, rules, procedure, and have unified court systems, mm-hmm. and not so many courts that has existed in some counties, but to have it unified into one court or system. And so they made this recommendation, and so first the first reforms were to sort of increase the number of the state Supreme Court and to create a different type of court of appeals in the state.
Mm. What was the importance of increasing the number of justices?
Well, it was that the workload was heavy on the 7 and at that time, and so they increased it by 2. Now, Governor Brewer was then governor, and his legal advisor, Hugh Maddox, who later became a member of the Supreme Court, thought that these things were good and advocated them. And so they were able to pass a small amount of judicial reform at that time. And then when I was elected Chief Justice, we had a program designed to go ahead and to fully implement the recommendations of the Citizens Conference. One of the things that struck them the most is they wanted to abolish the justice of the peace system. And then they were for a package, a unified court system, where you'd have a court for smaller claims and for certain crimes like misdemeanors. And then you'd have the court of what they call the court of original jurisdiction, or that's really the circuit court. And from there you would then have an appellate court that would hear appeals on things. You can have two. We ended up with two appeals courts. I don't know whether that's really necessary, but anyway, we found we couldn't. We ran into too much opposition when you tried to unify and have it only one court of appeals.
So there was a civil appeals, that this was on the agenda at least, to have a court of civil appeals and one of criminal appeals.
That's right. And so that was adopted. Well, at the same time, Governor Brewer had appointed a panel of experts, really fine experts, and they had as their executive secretary, and who really did the research and the writing for him, the former dean of the law school at the University of Alabama, Lee Harrison. And Judge Conrad Fowler was the chairman of that committee. And they wrote a new constitution for the state. Well, they did an excellent job. About that time, Virginia adopted a new state constitution. And so there was a movement among states to try to adopt and bring up to date their constitution.
Looking at the whole document.
Their whole document. And then we worked with them to insert in their new constitution a article that dealt with the courts. And so that was there, and we worked on it, but we first before we adopted the judicial article, a year or two before that, we had two constitutional amendments, one abolishing the justice of the peace that was adopted and approved by the people, and one dealing with discipline and retirement of judges. And that was adopted. And then the judicial article, the retirement and discipline of judges article was adopted really from that constitutional amendment. And so it was adopted early, but then later it was put in a few changes.
When you were beginning to design or think about what the judicial article ought to have in it, what the court system ought to look like, what were you confronting there? Your mindset would be interested in, and would be interested in also knowing what the challenges were out there in terms of mindset.
Well, there were a lot of mindsets. First is just the mindset of opposing change that exists in a number of people. They get in an office and they've been there for years and they don't want to change it, and they don't want to change their ways. That's just sort of a human habit that's almost found in every class of humankind. Well, you face that. Then you faced at the same time this in the 70s. This was around 73. It was adopted. You had this feeling among some people, which came out of the civil rights movement of being opposed to anything that had ever had the name federal in it. And the fact that some of the rules of procedure were adopted from the federal rules of civil procedure had a mindset of being against anything because it was federal. Well, we wanted to adopt what they call a Missouri plan for a selection of judges and tenure judges. Well, there was great opposition against doing anything that would change the method of election of judges. Then you had a mindset in regards to certain people in like probate judges, circuit court clerks. They were on a fee system.
Oh.
And so the fee system, they didn't want to lose out of there. There was one circuit clerk that was he was making at that time about $100,000 in fees, and he would be placed on a salary, and the salary would be substantially less than that at the time. Well, you had that you were fighting.
So people were looking out after their own
after
territories and not necessarily at that point thinking about the big picture.
They were protecting their turf, and they were protecting their pocketbook in so many instances, such as that. And then we had really the opposition of the governor. He didn't. Many of the things that I mentioned before were reasons why he says that he was opposed to it. So we had that, but he didn't. His brother was a circuit judge, and his brother became convinced that we needed to move forward and adopt this, and he had some influence on him. But rather than he coming out and opposing it himself, many of his lieutenants and allies, such as his leaderships in the House and in the Senate, opposed it. And so we were faced with the thing on the last day of the legislature. We had been passed the Senate. There were Lieutenant Governor Beasley was for it, and a great number of them, and we had later Judge Talbot and then Senator Stuart O'Bannon, who was really they had passed it in the Senate, but in the House we couldn't get up on the calendar to be voted on. And the last night of the legislature, they had to suspend the rules in order to get up on do away with the calendar that the speaker had put out. And so they finally ended up having to get a 4/5 vote, which was almost remarkable that any piece of legislation should do it in the House of Representatives to pass it. Then you had the conference committee, and you had to get it signed by the Speaker of the House and the Lieutenant Governor before
and meet the deadline.
Midnight.
Yeah.
Well, before that, we had a problem about getting it out of committee. And an interesting thing happened. We had a representative from Mobile by the name of Casey Downing, and we had counted him as being for the judicial article. Well, we learned that the night before the committee was to vote on it, that it would be tied. It would be tied and wouldn't come out of committee if we lost one vote. And then we began to hear that Casey was changing his mind. So I got on the phone and phoned a member of the Citizens Conference who lived in Mobile, who was Monsignor Oscar Lipscomb, who is now the Archbishop of Mobile. And he phoned to Casey and got Casey to go with us, and with Casey's vote, we got out of committee. That just illustrated some of the problems you had in the legislature.
Indeed, and the citizens conference group were very, very important, were they not, in the lobbying effort in the legislature?
I was going to mention that the Citizens Conference and many organizations, the League of Women Voters was very crucial to us, and they were very helpful. They had contacted certain legislators and gotten them to commit to support it. And then the Junior Chamber of Commerce group, the JCs,
I think I read AUW, the Junior League and women's groups.
Yeah,
lots of business groups.
Yeah, a lot of people in business groups and things else. They were convinced. See, the Citizens Conference, they went out and they were evangelists for the judicial reform. I don't know whether evangelist goes beyond a religious thing or not, but it seems to me to be a good term for going out, and rather than calling people lobbyists, I think sometimes they can be evangelists for a cause, and so I think maybe that may be a proper term. I'm not sure. They found out that the only chance they had of passing anything at the time was the judicial article, and so they put in effect on the back burner their rest of their articles of the proposed constitution that they had worked on for several years, and it's still there, and it's a very good document that ought to be followed to with changes today. We were on the ballot with the farmers for poultry problems, poultry products, and they were coming up for having a set aside of some money when pigs and hogs and things else were sold, and so we got along with them, and so we were being voted, and we both wanted the approval by the people, and so we ended up with a slogan of pigs and judges. So that was sort of a humorous thing, but it helped us get some votes on the thing, and the judicial article passed by about a 2-to-1 vote.
And I understand some 45 organizations, many of those statewide, were part of your campaign to actually get this. So all of the seeds you had sowed, all the educating you had done, the legal profession was behind you, strongly behind you, and then all of the citizens groups that knew this hodgepodge of courts had to be fixed, got into the army, if you will, the Howell Heflin Army, and you trained. I was visualizing this as I was reading the book, which we're going to talk about at the end of our taping. But it was perhaps the most important reform, constitutional reform, that we could ever come up with, because justice, even-handed justice, is very important to the fundamentals of the democratic process. So, any other thoughts you want to leave?
Well, you have to have support, and people don't realize that state senators and legislators, they come back home, and if some important people back home speak to them about an issue, then they'll as the country saying goes, they'll stay hitched. Yes. And they'll stay with you in regards to voting on when it comes up for a vote. And we want the fact that we got better than 4/5 vote in suspending the rules and letting the members of the House of Representatives vote on that meant that we had really a widespread
going into the campaign.
Back home work in regards to it. Now, there are judges that were for it, and there are lawyers that were for it, but there were many citizens that were for it, and many organizations. In other words, after that citizens conference met, the League of Women Voters was convinced, and then they began to talk, and they began to put it on there.
And it just spread.
And it spread, and that's a sort of a way that has to be done on the thing.
And the education that happened gradually was probably an important aspect of the success of this campaign to reform the judicial article.
Yeah.
Let's just summarize now what all was accomplished in this, just as a summary of this judicial reform. When it was all said and done, what were the key areas of improvement?
Well, it created a unified court system for the state, and it established a disciplinary system for judges, which we saw work recently in regards to removal of a judge. A judicial inquiry commission, similar to a grand jury, felt that there was probable cause, and the court of a judiciary decided that judge should be removed from office. And then he appealed to the Supreme Court, and they affirmed the court of the judiciary. And that was one of the measures that was adopted. It had rulemaking power that was given to the Supreme Court to
so there would be consistency.
Where there could be consistency, and if there's a need for a change, it would have to go through the legislature, but it could be changed by the court system. They put the registers and the clerks in the courts became state employees, and they had a retirement system which was very helpful to them. They meet under the judicial article and are educated as to methods of keeping their office and keeping the court's papers and files in proper condition. There is a major change from the old system into the new system, and it followed pretty well what the Citizens Conference had advocated, what the Advisory Committee on the new state constitution had recommended, and all of that, except that they retained the election of judges. Yeah, we have practically the system that we wanted to do in effect in Jefferson County and in I believe Mobile County. I think there are 3 or 4 where if there's a vacancy, the commission determines whether or not who are qualified, and they will submit to the governor 3 names, and then he selects that one, and that selection process, the tenure process, is where a judge runs against himself. He doesn't have an opponent, but he has whether the election is whether or not he ought to be retained in office for another term. And that was not adopted, but there was too much opposition in regards to that.
If you were doing constitutional reform today, if you were working in constitutional reform, how would you approach it? Because as you know, there's still a lot of work to do in constitutional reform. How would you approach it? What would be your strategy? Just a very quick thought on that.
Well, I think following the basic approach that the judicial reform followed would be appropriate. And doing it, it'd be different, but I think you need citizens, or you can gain everything else. You need citizen support. You need organization support. You need a lot of things like that to gain support. Now, there is some states have had, when they have had changes in the Constitution and the new Constitution have adopted, they have had constitutional conventions.
Mm-hmm. How do you feel about that idea?
Well, I'm scared of it.
Okay.
There is no really, I think, no really easy way about adopting the Constitution, but you have either the legislative route or the constitutional convention route. Neither one of them are without fears and without pitfalls. There are problems involved to it. A constitutional convention is a one house, is a unicameral body. It adopts its own rules. It is elected. There is no assurance that the special interest that is involved will not be electing its members just as they probably do in the state legislature.
Mm-hmm. Exactly.
So there are problems. The legislature has two houses, and if adopted one, if changes are needed or some compromises needed, they can be worked out. They have the filibuster rule. The fear of a constitutional convention is that it will be, the special interests will be elected, will elect their members, adopt their rules, and it will then go to the people. And the chances are that you can get a constitutional, new constitution for the state through the constitutional convention approach is questionable, just like it is with the legislative route. But I have fears that it opens up the entire Constitution and that they can change things. You got special interest today. Mm-hmm. Take the issue of well, I'd say it started to say religion. You can overdo it, or you can not do enough on freedom of religion. And you know, surprisingly, the Alabama Constitution and its Bill of Rights, other than the things that it did relative to race, has a lot of good language in it. But the race language is terrible in it. But
hopefully that's going to be
removed
again to be removed.
Yeah, and I hope, and I think it will.
But
the Supreme Court has ruled you can't, through the legislative route, you can't adopt a new constitution in its entirety.
Okay.
So it'll have to be adopted by articles, as I understand
incremental.
That's right, incremental parts. So I don't know, but I got fears of both ways. So
you don't have a preference at this point necessarily.
Well, I reckon my preference is more the legislative route. I can see a group electing their people in their special interest group today with the atmosphere about certain issues that they would that there's a little more danger through the Constitutional Convention than it is through the thing. But we want, but let me say this, regardless of how it goes, I'm for a new state constitution, whether it goes the constitutional convention route or whether it goes the legislative route. I just,
We need a new one.
we need a new one, and we ought to adopt it, and we ought to get about doing about business. But it's going to have a tough time going either way.
Yeah. And keeping statutory law out of the Constitution, I think, would be a major issue that needs to be firmly established.
Yeah, there too many of them want to write things into the Constitution that don't necessarily have to be there.
Can you spend just maybe a minute telling us what are the major issues of this state? What are the governing issues of this state? The governing issues.
Well, I think I say this, that Governor Riley was very courageous in my judgment. I'm a Democrat, but I thought he was very courageous in proposing what he proposed.
The Amendment 1
which failed, and failed by a big vote. But nevertheless, he was very courageous in doing it, and I think he had a lot of good things in that.
Mm-hmm. Tax reform.
Tax reform, of course, is a major issue that's confronting the state, and poor people pay a disproportionate share, and it's a larger share, percentage-wise, of the overall income it comes into the state treasury, and it coming from poor people. They are. We've got a regressive tax system in Alabama that needs to be changed. But anyway, it didn't pass, and so we confronted with that. And but tax reform is one of the major things that is needed in the state. I'm sure that there are many other things that we need in regards to the new Constitution. We need to remove all that racial language. The Constitution of 1901 was called, and it was there to be, and it was adopted with the idea of disfranchising a great number of the population of the state. It was primary. Their proposal was not adopted, and we were able to defeat it. And then there were a good number of civil rights bills that came along, and then there was the issue of certain judges that shouldn't go on the courts that we had to face and sometimes leave. And at the same time, we were trying to appoint more black judges in Alabama, which we succeeded in doing. I really feel that we made a mistake, and perhaps it was a thing that was wrong. It was that the fact that Fred Gray, who was proposed, and he had a lot of opposition, but I don't think that he's a very ethical man. He served as president of the state bar now, and he's very competent and could have made a great judge. But at the time, we couldn't get the votes to get him through. There had been a lot of charges made, but most of those charges were not substantiated, and so we were facing an end of a session, and the only way we could do it was that we had to get another person, and we got Myron Thompson, who is a judge in Montgomery, and his mother was the registrar at Tuskegee University Institute then. But and he had started out practicing law in Dothan. I think he had some relatives down there, and he's made a very fine judge.
What state, how are we doing in this state right now?
Well, we are making progress, but you know, the matter of it is whether or not individuals would really are willing to accomplish things. Are they willing to, say, bring blacks into their homes? Or whether blacks, on the other hand, are willing to have whites. Whether there's an interchange of, in churches. Now, there's all, I think we accept that the blacks want a predominant black church. They don't necessarily want an integrated church. But there are places where that integrated churches would exist. But on the other hand, I think we ought to have choirs that go and sing in black churches from whites, and then we ought to have interchange of ministers and preaching and things else like that, if they are Baptist preachers or if they're Methodist preachers or whatever the denomination might be. Mm-hmm. I think that would help in regards to advancing the cause of racial progress and things. And there are other things that we need to do. The school kids are doing a good job. I mean, they are more and more today becoming where they know each other, and but still, it's still that idea of you see groups off together, rather than, and there are things like that I think that we need to do it. It's a matter of individuals, whether you are really.
Now it's a matter of choice, you're saying, aren't you?
Yeah.
In some ways.
Yeah.
Rather than a matter of the law, a prohibition.
Well,
and that sort of thing. So we've made great progress.
Well, we've made great progress in eliminating the discrimination that existed, and trying to put equal rights and equal opportunities on it. And there's criticisms of that. There are criticisms of the affirmative action programs. And affirmative action will eventually have a termination date. But we've got a lot to go before I think we reach that.
Absolutely. Judge Heflin, it's been a pleasure to have this opportunity to hear your thoughts and to get some guidance through history on judicial reform. Thank you very, very much for joining us today.
Well, thank you.